How does an on-the-job accident case work?
Hi there, folks, and welcome back to our series of frequently asked questions. I'm Jim Adler, the tough, smart lawyer. Today, we are going to talk about work-related accidents and especially third-party claims.
One of the most complicated types of personal injury accidents occurs on the job. This is for many reasons, some of which are unique to Texas, making handling these types of claims and lawsuits very complicated. This is why victims and their families should call our experienced Texas workplace accident lawyers at Jim Adler & Associates for help after any work-related accident. Several important considerations must be carefully evaluated for an on-the-job accident in Texas. These include the following: workers' compensation. Most workers who are hurt on the job will have workers' compensation, a no-fault system of benefits that may allow an injured worker to recover a percentage of lost wages, medical bills, and related damages for a work-related injury or illness. Although this sounds like a great option for an injured worker, the truth is that workers' compensation does not afford money for pain and suffering, which is often the largest component of a settlement or verdict in a negligent accident. Therefore, individuals hurt in work-related accidents or due to work-related illnesses may be barred from recovering pain and suffering because they cannot sue an employer for negligence. Third-party claims. However, while workers' compensation covers nearly all types of work-related injuries or illnesses, an exception is where a third party's negligence may have caused the injuries, not the employer. In this situation, an injured worker may be entitled to recover compensation from a third party, including for pain and suffering. This means that a worker may be entitled to recover more compensation than what they would have solely in a workers' compensation claim. An example of a third-party claim would be when a worker is driving between job sites for work and is hit by a drunk driver on the road. The worker may be able to commence a third-party claim against the drunk driver to obtain compensation for pain and suffering. Jones Act claims. Some on-the-job injuries may also be covered by the Jones Act, a federal law that applies to seamen injured at work. Unlike workers' compensation laws, the Jones Act allows a victim to sue an employer for negligence. However, only certain individuals may be covered by the Jones Act, and not all jobs or job locations qualify, i.e., it must be an afloat and mobile vessel on navigable water.
We understand that these on-the-job accidents are complicated and potentially overwhelming if you have already been catastrophically injured or lost a loved one. Learn how the experienced workplace accident lawyers at Jim Adler & Associates can help you and your family during a free consultation after an accident. You can reach us on our website at jimadler.com or by calling 1-800-567-7575.